Okay, hey everybody, it's Straight Out of Context. I hope you're all doing well. I've been doing, because I have all of the filings for the Blake Lively, Justin Baldoni case, and I have been covering it. I've been talking about it, all of the things that have come out, the exhibits, and it's a lot. It really is a lot, because if you don't know, Blake Lively filed a CRD. It's the California Rights Department complaint, which is what they call the CRD complaint. Okay, that was her complaint with the state of California. The California Civil Rights Department. That's what it should be, CCRD, really, but they call it the CRD complaint. It's the California Civil Rights Department. So CRD is Civil Rights Department. She filed that with the state of California because this has to do with their workplace, and then she named somebody named Jed Wallace and his PR firm called Street. And that was in the original California state filing because it has to do with a workplace. They gave her a writ, which is like a letter to sue. She then files federally in the state of New York, but then Jed Wallace's name and his company was just magically off of the federal New York filing. So she's got that lawsuit. Then Justin Baldoni. So technically that's two different filings. There was the legal complaint, and then she actually got the permission to move to a lawsuit, and she filed the lawsuit. So then Justin Baldoni sued the New York Times for $250 million because WME, which stands for William Morris Endeavor, it's the largest talent agency in Hollywood, ended up dropping him 24 hours later from a $250 million contract that he had with them. I mean, they represent people like Angelina Jolie, like A-listers. And so he is suing the New York Times for $250 million. I have all of the lawsuit documents, all of them. And nobody has this one, but I got my hands on this one. That's what I worked on the last couple of days, and I have them available on my YouTube channel for people to read, to pause to read if you like. But then he also is suing Blake Lively, Ryan Reynolds, and Leslie Sloan, their PR agent, manager, whatever you want to, publicist, you want to call it. He's suing them for $400 million. And his lawsuit was bombshell because the exhibits show in context what Blake Lively took from her CRD complaint completely out of context. She really did cherry pick little pieces of emails or text messages where he includes a lot more. And he shows here, this is what her complaint says. Here's all of it. Here's the truth. So that's 4. Now Jed Wallace is in Street Relations, which is his PR firm, is suing Blake Lively for defamation. Then there's Stephanie Jones, who owns Jones Work PR firm. That was Justin Baldoni's former publicist, or crisis publicist, whichever one she was. She is suing Justin Baldoni for set amount of money, for breach of contract, whatever. So there's technically, there's 5 now, but there was technically 6 different legal filings or lawsuits filed. This one is a 10-page civil action, number 25-163. The United States District Courts for the Western District of Texas, Austin Division. This is Jed Wallace. His company, Street Relations, Inc., is the plaintiff versus Blake Lively, defendant. This is a complaint for declaratory judgment and defamation. So Jed Wallace and Street Relations, collectively, the plaintiffs bring this action for declaratory judgment and defamation against Blake Lively, who would be the defendant, and would show as follows. Wallace is a citizen of Texas and resides within the Austin Division of the Western District. He owns a company, Street Relations Inc., Street, which is a crisis mitigation firm engaged by clients to help navigate real-life human crisis, threats, trauma, and mental health concerns. It helps primarily families and individuals when they find themselves unjustly attacked, extorted, doxxed, swatted, scammed, or need help navigating through the most frightening situations. Page 2. Street is a corporation organized under the law of the state of California with its principal place of business in Texas and is therefore a citizen of a state other than New York. Lively is an actress and entrepreneur and is a citizen of New York. Factual background. On December 20th of 2024, Lively filed a complaint of employment discrimination before the State of California Civil Rights Department, the CRD complaint. The CRD named Lively as a complainant and Wallace and Street, among others, as respondents, and alleged that they had engaged in a variety of conduct in violation of the California Government Code Section 12940, the FEHA, and Title VII of the Civil Rights Act of 1964. The CRD complaint went on to allege the plaintiff's conduct includes harassment, retaliation, failure to investigate, prevent, and or remedy harassment, and aiding and abetting harassment and retaliation. Exhibit 1 of the CRD complaint is attached. The CRD complaint also asked politely to please see attached complaint for specific details. The attached complaint, which we attached as Exhibit 2, has been described as a precursor to a lawsuit, although it had all the indicia of a standalone legal complaint. Indeed, some media subsequent published the precursor under the headline, "Read the Complaint." The precursor named Wallace and Street as defendants and sought damages for harassment under California and federal law, retaliation under California and federal law, this is page 3, failure to investigate, prevent, and or remedy harassment under California law, retaliation under the California Labor Code, aiding and abetting harassment and retaliation under California law, breach of contract, intentional infliction of emotional distress, negligence, false light and invasion of privacy under the California Constitution, and interference with prospective economic advantage. On the same day the CRD complaint with the precursor attached was filed, December 20th of 2024, the Civil Rights Department issued Lively a right to sue letter, a letter saying that she has the permission to move ahead with the lawsuit. And it says, see Exhibit 3. I did not save all the exhibits, because don't really need them. You know, you guys have probably already seen all the exhibits. I have them all already documented on my YouTube as well. And it says, Lively or her agents provided the precursor to various media entities for out-of-court republication, and because of the allegations contained therein, it made headlines around the world. According to Elle magazine, which linked the precursor document, as did many other media, see Exhibit 4 attached, the precursor was followed on or about December 31st, 2024 by a formal suit, meaning a formal lawsuit, in the United States District Court for the Southern District of New York. That is when she actually filed her lawsuit. There's the CRD complaint in California. She got a letter to sue. She filed it federally in New York. Wallace and Street are widely reported to be defendants in the formal lawsuit, although they were not. She suddenly dropped him and his PR firm. She just didn't even know this guy, didn't even have no evidence or proof whatsoever that he had anything to do with Justin Baldoni or helping him to go on this smear campaign. And then she just gets this letter to sue and then suddenly drops his name and his company as being defendants. What is going on? What is going on? Although they were not, the confusion having been sown by the precursor. As Lively later admitted, she knew of no facts to support the allegations of Wallace or Street. Indeed, having been the one harassed, she knew the exact opposite. Neither Wallace nor Street had anything to do with the alleged harassment, retaliation, failure to investigate, or aiding and abetting the alleged harassment or alleged retaliation. Neither could they have breached a contract with Lively because no such contract exists. And they were not involved in any of the events depicted in either the precursor where they were named as defendants, or the formal lawsuit where they were not named, which could give rise, and this is page 4, to a duty towards defendant negligence or any other torturous conduct, false light, intentional infliction of emotional distress, or interference with prospective economic advantage. Then, on January 21st of 2025, Lively filed her verified petition for Rule 202 deposition. She filed the petition for the Rule 202 deposition in Hays County, Texas, against Wallace, but not Street, his company, alleging on information and belief that Wallace was a subcontractor to a company called TAG to assist them in their unlawful retaliatory social combat campaign against Lively. The 202 petition conceded that Lively has no facts supporting the allegations she made against Wallace or Street in the precursor, which made headlines around the world, as she now, apparently under the threat of sanctions from one of the plaintiff's attorneys, sought to investigate the scope of Mr. Wallace's conduct. According to the Hays County online court records, Lively non-suited her 202 petition today. The 202 petition was a transparent attempt to chill plaintiffs' free speech rights and would have been fodder for a motion to dismiss under the Texas Citizens Participation Act, Chapter 27, Texas Civil Practice and Remedies Code, the anti-SLAPP statute, whose purpose is to encourage the safeguard and the rights of persons to speak freely. This is page 5 of 10. The statements of fact, actual or implied, of and concerning plaintiffs in the precursor and CRD complaint are false, defamatory, made with either negligence or actual malice, and have caused millions of dollars in reputational harm, including both general and specific damages through emotional harm. Wallace. Actual damages and real and projected loss of business, Wallace and Street, in the amount that exceeds $1 million. Jurisdiction and venue. The court has the jurisdiction under 28 U.S.C. because the matter exceeds the sum or the value of $75,000, exclusive of interest and costs, and Wallace and Street as plaintiffs are not citizens of the same state as the sole defendant, Lively. This court may exercise personal jurisdiction over Lively because she has availed herself of the form by filing a Rule 202 petition in Texas on the subject matter of this suit. And it states all these cases, of course, noting that well-established rule that the parties who choose to litigate actively on the merits therein surrender any jurisdictional objections. And then it states another case holding that there were no personal jurisdiction because the defendant never initiated an original action in Texas, which would have subjected it to personal jurisdiction. In addition, her defamatory statements were aimed at Texas, where both plaintiffs reside, and they undoubtedly cause harm in Texas. Page 6. Venue is proper because, as Lively alleges in a Rule 202 petition, a substantial part of the underlying events that would give rise to the claims of being investigated occurred in Hays County, part of the Austin Division of the Western District of Texas. C.R.E. Blake Lively. In addition, a defamation plaintiff is accorded great deference in his choice of form, especially when it is his home venue where the defamation is most keenly felt. That meets the standard for venue under the venue statute. And of course it has where it's citing all of the cases. And I'm not going to read all of that and all of the numbers and whatnot. And it says first cause of action. The Declaratory Judgment Act. The Declaratory Judgment Act allows a court to conclusively adjudicate and declare the rights and other legal relations of any interested party seeking such declaration. The purpose of the Declaratory Judgment Act is to afford one threatened with liability and early adjudication without waiting until his adversary should see fit to begin an action after the damage has occurred. It cites a bunch of lawsuits. The Fifth Circuit has long recognized the validity of such anticipatory declaratory judgment actions. See this case, see that case. The plaintiff in an anticipatory declaratory proceeding is seeking the adjudication of an issue that would arise in a conventional proceeding brought by the defendant. And the Fifth Circuit continues to recognize the issue preclusive effect of, this is page 7, such anticipatory declaratory judgment suits. see this case. As explained above, Ms. Lively has alleged 10 different causes of action against Wallace and or Street, although she now admits that the CRD complaint and the precursor, which caused great harm to plaintiff's business by way of loss of business exceeding the threshold monetary limits necessary for diversity jurisdiction, as it was reported around the world, was without factual support, even though she now blatantly attempts to obtain some through her 202 petition. See NRE blank Lively Sutra at 3820. The claim is jurisdictable, and the court has the authority to grant the relief plaintiffs seek, such as they did not breach any contract with the defendant for the reason that, among others, no such contract exists. They did not engage in any acts of harassment, retaliation, failure to investigate, prevent, and or remedy harassment, or aid and abet the alleged harassment or retaliation for the reason, among others, that they were not even present or otherwise involved in the events that give rise to the alleged harassment, nor did they have any contemporaneous knowledge of the alleged events or harassment or retaliation. Wow, this is a lot of really big words for me, guys. They did not have a duty to defend it, which would give rise to a claim for negligence. They did not engage in any torturous conduct towards the defendant. Plaintiffs seek a declaration pursuant of Section 2201. The precursor, this is page 8, and the CRD complaint named Wallace and Street as defendants or respondents and falsely stated that they had engaged in 10 illegal acts under the state and federal law. Neither the precursor nor the CRD complaint are privileged because, among other reasons, they were provided by the defendant and or her agents to third parties, including many media outlets. A defendant knew or should have reasonably anticipated. Indeed, she hoped that these allegations would be republished around the world. As a result, defendant is responsible for republication damages. The statement of fact of and concerning plaintiffs in the precursor are false and defamatory statements. They are made either negligently, if plaintiffs are private figures, which they are, or with actual malice if plaintiffs are public figures, which they are not. The statements have caused both the original publications and the republications around the world great harm to plaintiffs, and such damages are presumed if some or all of the settlements are defamatory per se, or per quad, if not per se, and in any event exceed $1 million. In considering whether $75,000 jurisdictional amount has been reached, the court can take notice that many recent awards, Freeman and Moss versus Giuliani, or settlements, Dominion/Fox, Trump/ABC, those are 3 of the cases they're citing, far exceed that amount. Although Lively is a public figure, Wallace and Street are not. Thus, plaintiffs need prove only negligence to establish liability. However, plaintiffs also seek punitive damages in the amount not less than $6 million, and to satisfy the evidentiary burden in establishing the right to such damages, they must demonstrate actual malice, that is, that Lively either knew the allegations were false at the time she made them, or she acted in reckless disregard for the truth, that is, she had a high degree of awareness of falsity, falsity, and in fact entertained serious doubt about their truth. She acted with actual malice because she was one claiming to have been harassed and retaliated against. She was not the one who claimed she had been in contract with the plaintiffs, and yet there is no such contract, and plaintiffs were nowhere near where the alleged harassment and retaliation took place. Lively knew this, and it is not the case that she was harassed by some masked stranger who turned out to be the plaintiffs. She knew and knows that they were not the harassers, retaliators, but made these allegations anyway, leaked them to the press hoping that they would widely be republished, which they were, but then excluded plaintiffs from the formal lawsuit in New York City, knowing they had nothing to do with the events depicted therein. Plaintiffs, under federal rule of civil procedure, demand a jury. Plaintiffs, therefore, respectfully request that this court to enter a final declaratory judgment under 28 U.S.C. 2201 as requested, supra, and an award damages for plaintiffs, loss of reputation, and for further relief at law or in equity as to which plaintiffs may be entitled. Dated February 4th, 2025. Respectfully submitted by Jackson Walker, LLP. Attorneys for the plaintiffs. And there you have it, y'all. If you're interested, maybe, just maybe, we'll be able, I'm not going to show you all the pages, okay? Because I'm not going to republish any of that, but we might be able to go over some of these medical records and talk about some of the stuff that's in here regarding Gypsy Rose Blanchard. But it is what it is. So y'all have a fantastic Valentine's Day. I love you all. Thank you for watching, and have a great night. I gotta go check my turkey because I've had a turkey in the oven. Yeah, it's been in my deep freezer. Gotta cook it. So, alright, bye y'all. If you want, send me all the love you can. Subscribe, like, comment, share. Stick around. Give me a chance. You might like what I have to say.